today's press conference called by Endsars United in conjunction with the radical agenda movement in the Nigerian Bar Association, Ramimba. My name is Adeshina Ogunlami. Good morning, ladies and gentlemen of the press, compactors and comrades. The tolling is now ongoing on the Ikoyi Link Bridge as we speak. For the mere fact that the Lagos State government think they have the legal right to toll on the bridge, on that bridge, is an insult to the law and the memories of citizens that lost their lives at the Lekki toll gate on October 20th, 2020. The topic is the illegality of the tolling of the Ikoyi Link Bridge, justice for Endsars victims, and the state of the nation. The summary of the response of Lagos State government is that it has a pending appeal against the case of Olu Adegboro Esquire versus Attorney General of the Federation and others. Suit number FHCL is supplied, delivered by the Federal High Court on 27th March 2014. The basis for this argument is that the records of appeal at the Court of Appeal on 11th November 2014 and what was struck out in the Court of Appeal ruling of 9th October 2017, in quote, was the application and not the appeal, as there's a distinction, according to them, between striking out an application and striking out an appeal. Mr. Moyo Onigbanjo Sam, the Attorney General of Lagos State, couldn't have misstated the law more violently or pressed it into the service of injustice and governmental fraudulence if he had originally set out to do so in the process of defending Lagos State government. The law, as we know it, requires an appellant to cause the registrar or the lower court when you are appealing. When you want to appeal, the law requires an appellant to cause the registrar of the lower court to compile and transmit the records of appeal within 60 days after the filing of the notice of appeal, or to do so himself within 30 days if the registrar failed to do so at the expiration of the 60 days. Kindly see Orders 8, Rules 1 and 4, Court of Appeal Rules 2021. The appellant may apply under Order 6, Rule 9(1), Court of Appeal Rule 2021 for the extension of time if he failed to comply and transmit the records of appeal within the prescribed time. The Lagos State government availed itself of the window for extension of time under the foregoing provision of the Court of Appeal rules when it filed an application for extension of time within which to compile and transmit the records of appeal at the Court of Appeal on the 11th November 2014. However, the Lagos State government sleeps on its privilege under the law when it abandoned the application and the appeal by extension by not appearing in court on the day the application was to be heard. I mean, they've done what they're supposed to do, but the motion or the application was not going to move itself. The lawyer must be there. I mean, you are the one who is complaining and you are begging for to be accommodated despite your tardiness. But you have to move it. They didn't do that. Because they were not there to move the application, the Court of Appeal struck out the application and the appeal. In the words of the Court of Appeal, and we quote respectfully, since applicant is aware of today's date and is not in court, we take it that the applicant is not diligent in the prosecution versus Umwani 2012 LPELR 9841 Court of Appeal. It was held thus by Order 8, Rule 18 of this court's rule, where there is a failure to compile and transmit competent records of appeal, the appeal will be dismissed. See also the case of Nigerian Navy versus Labinjo 2012 17 Nigeria Weekly Law Report Part 1328 56. Therefore, the government of Lagos State has hit a brick wall on its matter and cannot take any further action in relation to the matter. The position of a record of appeal is germane in an appellate court process. This is so much so that absence of record of appeal or incompetent record of appeal clearly robs the court of competence to determine an appeal. According to the Court of Appeal in Kilawa against Achingu and Ananda, 2015 LPLR 41625652, the Court of Appeal said the issue of competence of the record of appeal raises in a very frontal way the issue of the jurisdictional competence of this court to hear and determine this appeal on the merits. It is important to highlight that the Court of Appeal held, quote, the number deleted. It means only one thing, that the appeal number has been struck out. This is the only reasonable interpretation to reach as an application brought under a substantive appeal and the appeal of the ground of lack of diligent prosecution. This want of diligent prosecution in the prosecution of the appeal by the Lagos State government has made his position so incurably bad to the extent that the appeal cannot be relisted pursuant to Order 8 to 18 sub 3 Court of Appeal rules. This is in view of the express provision that an application for relisting of an appeal can only be filed within 7 days of the striking out order. Now, you are, even when you are not there to move the application, and the application does not have a life of its own, you are still given 7 days. You can still come back, cook up 1 or 2 excuses, and the Court of Appeal are very committed to the ideas of fair hearing and justice, and to preserve your right of constitutional right of appeal will still have allowed you. But did they do that? This is also in tandem with the decision of the Supreme Court in the case of Governor of Zamfara State and others versus Yalangbe, another 2012 LPLR 9715 Supreme Court, which is to the effect that such provision cannot remedy an appeal which is dismissed for lack of diligent prosecution. If the Lagos State government felt aggrieved by the 9th October 2017 ruling, remember now, it took them 3 years. 2014 thing was struck out. They came back and it took 3 years, 2017, and before it was eventually struck out because they were not around to pursue their application to get relisted. They struck out his application appeal. He still had the option of challenging the ruling of the court and having it set aside his order by bringing an application pursuant to Order 6 to 10 Court of Appeal rules, as you have said. This can only be done within 14 days after the ruling. Again, this was not done. At least there is no evidence that this was done. Even if the government of Lagos State obstinately, though erroneously, believe it has an existing appeal, it's only expected that it should have taken steps to prosecute the appeal since 9th October 2017. Gentlemen, I hope you are following. Yeah. Assuming that it even believes erroneously, what have they been doing since 2017? Nothing. Instead, after the Court of Appeal ruling of 9th October 2017 rendered the defective record of appeal irredeemable and the appeal still born, the state government are continuing to parade a non-existing appeal. This is Jankara practice. Lagos State government is doing Jankara. Abuse their powers as executive, insult the judiciary, extort money from people by saying, oh, we have a pending appeal. Which appeal? They are continuing to parade a non-existent appeal as a basis for flouting the judgment of a court of competent jurisdiction. It is pertinent to note that the Lagos State government claimed that in a statement that the Federal High Court did not specifically or expressly grant the injunction sought in the matter. This is what the Honorable Attorney General and Commissioner for Justice Lagos State, Moyosoro Onigbanjo Esquire, SAN, was saying about 10 days ago. If we are to accept this position as correct, then the question will be, what orders did the government of Lagos State was then seeking to stay when it applied for stay of execution of judgment of the Federal High Court? Let me take that again. The Attorney General, Onigbanjo SAN, claimed that the order of the Federal High Court did not specifically or expressly grant the injunction sought. Now the question is that then, what are you appealing? If you say according to you, there was nothing granted, there was nothing expressly granted, then why did you go to Court of Appeal? You see, this is trying to be clever by half and speaking from two sides of the mouth, approbating and reprobating, and this will not be allowed. If we are to accept this position as correct, I reiterate, then the question will be, what orders did the government of Lagos State seek to stay when it applied for stay of execution of the judgment of the Federal